Today, we're tracking a flurry of legal clashes shaking American society. First, can you be detained for flatulence during a police encounter? We'll examine when passing gas becomes a matter for the courts. Then, a federal judge deals a blow to Trump's mass deportation plans as families of deported Venezuelans plead for release from El Salvador's prisons. And finally, Harvard University faces an unprecedented threat as the IRS considers stripping its tax-exempt status, a move legal experts call potentially illegal. Let's begin. In a bizarre twist of law enforcement, flatulence has become a surprising factor in police encounters, creating both humorous moments and legally complex situations. But can passing gas during a traffic stop actually land you in legal trouble? While no explicit traffic laws address flatulence in vehicles, some municipalities have created ordinances regulating this bodily function in specific public spaces. In Port Arthur, Texas, local ordinances explicitly prohibit flatulence in elevators, classifying it as a form of public nuisance. The city law specifically advises residents to hold it in or wait until reaching more open areas before releasing gas.
Just ripped one, man. You gotta warn me. You gotta, man.
I have some questions for you, but I need to see your face.
How far are you right now? I just ate.
This clip from the popular show Live PD captured one of the more widely viewed incidents of flatulence during a police encounter. The segment from August 2019 shows officers dealing with an individual who flatulates directly in front of them after being placed in the back of a police vehicle. The question of whether it's illegal to flatulate in the presence of a police officer isn't explicitly addressed in most legal codes. However, the context and intent behind such actions could potentially influence how they're interpreted by law enforcement. If a flatulent act were deliberately directed at an officer in a manner considered disrespectful or obstructive, it could potentially be construed as disorderly conduct or even obstruction of justice. In another remarkable case from Missouri, a fugitive inadvertently revealed his hiding location to police when he passed gas loudly enough for officers to hear him. This incident demonstrates how bodily functions can sometimes undermine even careful attempts to evade law enforcement. Police interrogations have also been the setting for flatulence-related incidents. A video from police cams shows a man who flatulated during a formal police interrogation, creating an awkward moment that interrupted the questioning process.
Yeah, man. Nah, I don't know why we in charge.
In another traffic-related incident, body camera footage documents a suspected drunk driver in West Melbourne, Florida, who specifically requested permission to flatulate during a traffic stop. This unusual request occurred while officers were preparing to conduct a field sobriety test. Legal experts suggest that while flatulence itself is rarely the direct cause of legal trouble, it's the surrounding circumstances and how the action is perceived that could potentially lead to charges. A TikTok legal analysis by the account Law by Mike directly addressed the question, is it illegal to fart on a police officer, providing legal perspective on this unusual query. So while you're unlikely to get a ticket specifically for passing gas during a traffic stop, remember that context matters. And in confined spaces like police vehicles, a little courtesy goes a long way. Up next, a federal judge has delivered a significant blow to the Trump administration's deportation strategy, issuing a permanent injunction that blocks the use of a 226-year-old law to deport Venezuelan migrants. On May 1st, 2025, U.S. District Judge Fernando Rodriguez Jr., a Trump appointee, ruled against the administration's attempt to use the Alien Enemies Act of 1798 to deport Venezuelan migrants detained in the Southern District of Texas. This 36-page ruling represents the most expansive judicial rebuke to date of the administration's aggressive immigration crackdown. The controversial law, enacted in 1798, allows the president to detain, relocate, or deport non-citizens from a foreign nation during times of declared war, or when the U.S. faces an invasion or predatory incursion. Historically, it was used during World War II to intern Japanese Americans, an action later acknowledged as a grave injustice. On March 15, 2025, President Trump invoked the act, claiming that the Venezuelan gang Tren de Aragua constituted a hybrid criminal state, perpetrating an invasion of the U.S. This proclamation aimed to expedite deportations without standard due process, such as immigration hearings.
Donald Trump is beginning mass deportations across the United States this week, and while he has not said exactly where the first raids will take place, he did say they will be arresting migrants in major cities first.
ICE raids have started in Chicago.
The administration used this authority to deport at least 137 Venezuelan men to El Salvador's notorious terrorism confinement center, CICOT, on March 15, 2025. Many of these men were accused of being Tren de Aragua members, though U.S. Immigration and Customs Enforcement, ICE, admitted that many lacked criminal records in the U.S., raising concerns about mistaken identities.
Does not mean that I am a criminal. A tattoo does not mean that I am a criminal. There's a saying that a tattoo doesn't make you a delinquent, any more than a tie makes you decent.
The American Civil Liberties Union, ACLU, along with other immigrant rights groups, filed lawsuits challenging the deportations, arguing that the act's use was unlawful in peacetime and that Tren de Aragua's activities did not meet the statutory threshold of an invasion. Judge Rodriguez's ruling agreed with the ACLU, stating that the Trump administration's invocation of the act exceeds the scope of the statute and is contrary to the plain, ordinary meaning of the statute's terms. He concluded that Tren de Aragua's alleged criminal activities did not constitute an organized armed attack directed by the Venezuelan government. The ruling permanently bars the administration from detaining, transferring, or deporting Venezuelans in the Southern District of Texas under the Alien Enemies Act. However, it does not prevent deportations under standard immigration laws. This decision marks the first time a federal judge has definitively declared the Trump administration's use of the Alien Enemies Act unlawful, unlike earlier temporary restraining orders issued by judges in Colorado, New York, and other districts.
Eso fue realmente una respuesta de lo que todos sabíamos. Ese es un secuestro. Nuestros hijos están vulgarmente secuestrados. Nuestros hijos están utilizando como mercancía. Y como mercancía como si fuera un perol que tú vas a cambiar. Y no debe ser.
The U.S. Supreme Court has also intervened. On April 7, 2025, it ruled that Venezuelan migrants must be given notice and an opportunity to challenge their deportations in court. On April 19, 2025, the court issued an emergency order temporarily halting deportations from the Bluebonnet Detention Center in northern Texas. The ACLU has raised concerns about deportees sent to El Salvador's C. Cote prison, where conditions are reportedly inhumane, including solitary confinement in dark cells. The U.S. is paying El Salvador's government $6 million to detain these migrants, prompting further legal challenges to secure their return. The Trump administration, through White House spokesman Kush Desai, defended its actions, asserting that Trump's 2024 election victory gave him a mandate to deport terrorist illegal aliens. The ruling can be appealed to the 5th U.S. Circuit Court of Appeals and potentially to the Supreme Court. The decision is a significant setback for Trump's immigration agenda, which has prioritized mass deportations. It reinforces due process protections for migrants and limits the use of extraordinary wartime powers in modern immigration enforcement. However, the ruling's scope is limited to the Southern District of Texas, meaning the administration could attempt similar deportations elsewhere, unless other courts issue similar injunctions. The ongoing legal battles suggest a potential constitutional clash between the executive and judicial branches. Up next, in a dramatic escalation of tensions between the White House and elite academic institutions, the IRS is reportedly weighing whether to revoke Harvard University's tax-exempt status, a move that could have profound implications for the nation's oldest university and potentially for higher education broadly. As of May 2, 2025, no final decision has been made, but the Trump administration is pushing for revocation, citing concerns over Harvard's policies, particularly around diversity, equity, and inclusion (DEI) initiatives.
No! Not for the reasons he thinks he can. He thinks he can do it because he doesn't like what they're teaching at Harvard. He thinks that invalidates its tax-exempt status. You can't do that. First Amendment protects private actors, including private actors fulfilling their charitable mission, even if the president doesn't like them.
Harvard University, like many nonprofits, holds tax-exempt status under Section 501 Part 3 of the U.S. Tax Code, meaning it doesn't pay federal income taxes due to its educational mission. This status is rooted in the recognition that universities provide significant public benefits through education and research. The controversy began with President Donald Trump's public calls to revoke Harvard's tax-exempt status, notably in an X post on April 15, 2025, where he questioned whether Harvard should lose this status if it keeps pushing political, ideological, and terrorist-inspired while supporting sickness. On May 2, 2025, Trump escalated this threat, stating via an X post that, "We are going to be taking away Harvard's tax-exempt status. It's what they deserve." The administration's concerns center on Harvard's DEI initiatives, which it claims may violate public policy. Executive Order 14,173, aimed at ending illegal discrimination, targets race-based and gender-based DEI activities, suggesting the IRS could apply the illegality doctrine to Harvard's practices. This follows the 2023 Supreme Court ruling in Students for Fair Admissions versus Harvard, which banned race-based affirmative action in admissions, potentially exposing Harvard to legal scrutiny if it continues such practices. Recent actions include Harvard renaming its Office for Equity, Diversity, Inclusion, and Belonging to the Office of Community and Campus Life on April 28, 2025, possibly in response to pressure. Additionally, the administration froze $2.2 billion in federal grants to Harvard, demanding changes like banning masks at protests and eliminating DEI programming.
I fully support it. I think it's important as a community here to, gather and face this all together. And I think this is an attack on academic freedom, and I think it's a threat to democracy.
Legal experts, including nonprofit tax attorneys, argue that revoking Harvard's status would likely be unlawful. U.S. law, enacted in 1998, prohibits federal officials, including the president, from directing the IRS to investigate specific taxpayers, a protection reinforced after the 2013 Tea Party targeting controversy. Harvard has stated there is no legal basis to rescind Harvard's tax-exempt status, warning that such action would endanger its educational mission, reduce financial aid, and halt medical research. Legal scholars assert the administration lacks a legal case, and Harvard would be well positioned to challenge any revocation. The process for revocation, if pursued, involves the IRS issuing a proposed revocation letter, allowing Harvard to respond within 30 days, potentially escalating to the IRS Independent Office of Appeals. Given the legal hurdles, experts predict any attempt would face court challenges, likely succeeding based on First Amendment protections for academic freedom.
I definitely hope that Harvard is going to use some of its endowment to, support continued financial aid for students, some of the critical research in, cancer research, medical research, and innovation that is happening at this place. But it is definitely gonna be felt.
Harvard's response has been multifaceted, combining legal action against funding cuts with public statements defending its mission. On April 21st, 2025, Harvard filed a lawsuit to halt the funding freeze, arguing it infringes on academic freedom. Compared to historical cases like Bob Jones University, where revocation was based on clear violations of public policy, racial discrimination, the current allegations against Harvard are less defined, focusing on DEI policies without clear evidence of illegality. If successful, revocation could force Harvard to redirect funds from educational priorities to taxes, impacting financial aid and research, with broader implications for higher education's independence. Conversely, a legal victory for Harvard could reinforce protections against political interference, shaping future IRS interactions with nonprofits. As the situation develops, stakeholders are closely watching for the IRS's next move and preparing for what could be a landmark legal battle with significant implications for the relationship between the federal government and higher education institutions.